Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 110. If you're worrying about the change of introducer, please don't worry. It's not that we pensioned Mr. Fisher off, it's just that we've needed to re-record the introduction and the ending to the podcast to take account of the fact that lawyers' CPD points are no longer current. And we weren't going to be allowed to put out a podcast with the old wording in it. Anyway, 3 cases, of course, we have 3 cases for you. And 3 cases this time round, well, they couldn't be more different. Indeed, one of them isn't even an employment case. First case deals with whether an employee being guilty of gross misconduct for failing to do something rather than for deliberately doing something. Second case deals with the existence of implied terms in a contract and when you can imply terms. And the third and final case deals with data subject access requests, which I have to say seem to be on the rise again. We went through a phase where there were relatively few such requests around, but lately they're definitely making a comeback. So the questions which the court had to deal with here are very interesting. As usual, please don't forget you can access the podcast. It's iTunes, it's on the Mayor Brown website, and it's on YouTube, and the Twitter feed, Nicholas Robertson at Nicholas ROBER11, which is also where we post out the links to all the cases that we've talked about in this podcast. So, first up, Adesokan and Sainsbury's Supermarkets Limited. Perhaps I ought to start with a health warning. I am definitely going to have to restrain my inner geek when it comes to dealing with this case, because I think it's really interesting. I know that's the kiss of death for any lawyer to say that something is really interesting, particularly to a client, but here goes. If you've not figured out by now that I find employment law interesting because it's both a real-world subject and a subject worth studying, then after all these podcasts, well, I've hidden the inner geek better than I feared. Mr. Adesokan was employed by Sainsbury's for more than 25 years. Prior to his dismissal, he was a regional operations manager. This was a senior post, and he had responsibility for something like 20 stores. Sainsbury's runs a process called the talkback procedure, which is designed to ensure that staff are engaged and motivated, which in turn, it's believed by Sainsbury's, will improve customer service. The information, of course, provided by staff is in complete confidence, and this process has been going on for many years, and the judge accepted, in his term, deeply ingrained in Sainsbury's culture. And the information that's gathered influences career progression, target setting, it's got an influence on pay, bonus, staff redeployment, and so on. So, obviously it's really important that the process isn't manipulated to achieve unduly positive, or I suppose unduly negative, responses. What happened was in June 2013, a talkback procedure exercise was being undertaken for about a third of the Sainsbury's stores, including Mr. Adesokan's. The HR partner for him sent a wholly inappropriate email encouraging the store managers covered by the procedure to focus predominantly on the most enthusiastic colleagues to fill in the survey. Although there was some suspicion that Mr. Adesokan knew about the email and had therefore condoned it being sent, it was ultimately decided he didn't know that this email had actually gone out. It was, of course, clearly contrary to the talkback philosophy to seek responses from the positive end of the spectrum only. Mr. Adesokan became aware of the email a week after it had been sent and 10 days before the end of the period in which staff were supposed to take part in the talkback process. He emailed the HR manager asking him to clarify what he'd meant by his comments, but otherwise took no further action. On the 1st of July, i.e. with 3 days still left to run, Mr. Adesokan realised the HR manager hadn't taken any steps to clarify the email to the store managers, but he still did nothing to remedy the problem. He did not, in particular, contact the store managers themselves to correct instructions or tell senior management what had happened. Well, after it came to light, there was a disciplinary process and Mr. Adesokan was dismissed. We don't know what happened to the HR manager. His name disappears from the case reports. I assume he was no longer there by the time Mr. Adesokan's dismissal is going through. Anyway, Mr. Adesokan's dismissal was on the grounds that he was accountable for talkback in his region. He was aware that the HR partner had communicated in a way that deliberately set out to manipulate the talkback scores, and he failed to take adequate steps to rectify this serious situation. Accordingly, To Sainsbury's, this amounted to gross negligence, and they said this was tantamount to gross misconduct, and so they dismissed him for gross misconduct. Contract of employment did not give a definition of gross misconduct within it, but there was a definition in the company's disciplinary and appeals policy, which was incorporated into the contract. Amongst other things, this included, quote, any serious breach of procedural policy that leads to a loss of trust and confidence, unquote. Just to add the icing on the cake, the evidence was that the talkback process in question was not actually affected by the offending email, and so the results coming in from his stores did not lack integrity. It was, of course, urged on the judge that this was a mitigating factor to be taken into account in Mr. Adesokun's favour, but the judge wasn't having any of that. Which I think is a bit interesting, because if Sainsbury's had to redo the talkback process because the information was compromised and had so incurred additional cost, then you can bet that would have featured as an aggravating factor. Anyway, Judge concluded, since it was the direct responsibility of Mr. Adesokun to ensure the integrity of the talkback process, and his failure to correct the email called into question his willingness to ensure that the process was a valid and proper one, it called into question his commitment to the process. The judge accepted that gross misconduct did not require dishonesty or intentional wrongdoing. Dishonesty and other deliberate actions would obviously poison a relationship, but so could an act of gross negligence. The High Court held, therefore, that the dismissal for gross misconduct was justified. The employee appeals. So the Court of Appeal, in essence, accepted the judge was entitled to come to this view. The critical feature was that Mr. Adesokun was responsible for ensuring the successful implementation of the talkback process in his region. Although he was not the person who was carrying out the exercise, once he was aware that it was compromised, it was his duty to ensure that it was remedied. The judge, the Court of Appeal said, was entitled to decide that his failure to act undermined the trust and confidence in the employment relationship, because Mr. Adesokun appeared to be indifferent to what was, in the company's eyes, a very serious breach of an important procedure. He should have reported the problem, he should have corrected the email. Stopping there, and there is one more point to go. I think the case is obviously fact-specific, but it is an important one. It's not unusual for an employer to find that an employee is significantly less competent or has made a one-off mistake. We've tended to feel that gross negligence was an extreme situation, really only something one saw every now and again. This was obviously an extreme set of facts, but the court has accepted that a failure to act can, in some circumstances, amount to gross negligence. And I think we're likely to see cases in the future where, for example, company performance has been poor, and the employer may try and run an argument that one or more of the directors have been culpably negligent, and that therefore amounts to gross misconduct. Obviously, it's going to be fact-specific. The facts are going to be crucial. But here, for example, what would have been the outcome if Mr. Adesokun had been on holiday for part of the period, or instructed the HR manager directly to correct or withdraw the email completely, but the HR manager did not do so, but Mr. Adesokun didn't realise this? The lack of explanation in the Court of Appeal's reasoning, at least, I think counted heavily against Mr. Adesokun. He didn't have a reason for not doing what he did, what he should have done. Certainly, I think the High Court's decision is entirely logical and rational in the way it approached matters. I think if this had been a call to me before they dismissed, I would have seen it as pretty close to the line between dismissal with notice and dismissal without notice. But given that he did have direct responsibility and that he failed to act despite knowing what he knew, then the tougher approach is completely understandable. I said there was one more point to get through. The claimant ran the argument that if he was wrongfully dismissed, contract law has now moved on from the classic position, which was the Gunton case, where an employee who is dismissed by an employer, where the employer, not the employee, the employer is in breach of contract, well, the employee's damages claim is limited to damages for length of the notice period. There was an argument that the Gies case, where, if you remember, the employee received an inadequate payment in lieu of notice without being told what it related to, the argument was that the Gies case means that the Gunton and earlier line of cases is no longer correct. In Gies, the employee did not accept the wrongful ending of his contract and was entitled to keep the contract alive for long enough to claim a very large bonus. The Court of Appeal, in this case, brushed the point aside. First of all, and obviously, because they decided that this was gross misconduct, they didn't really have to engage with the argument. The point was no longer live. But secondly, they said that it would be up to the Supreme Court to change the law based on Gunton. So, until further notice, sorry, pun intended, the rule will stand, and employees who are dismissed in breach of contract will not be able to claim damages beyond the end of the notional notice period in a breach of contract claim. I'd be really interested if anyone out there in listener land has a view if the Gies and Gunton cases really are compatible, but clearly for now the Court of Appeal doesn't want to say which is the rule and which is really the exception. So, that's the case of Adasocon and Sainsbury's Supermarkets Limited and Camden Market Holdings Corporation. Talking of contracts, this is a case about when you can imply a term into a contract. It's not an employment case, and I'll deal with the facts relatively briefly. The bank advanced loan facilities to Camden Market. Under the facilities agreement, the bank was allowed to assign or transfer its rights to another bank, with Camden's consent, but it could also provide information about the loan documentation and Camden ahead of any such assignment or transfer to the potential assignee or transferee. The bank, not Camden, the bank got into financial difficulties and a liquidator was appointed, who began marketing the bank's assets, including Camden's facilities agreement. Camden asserted this was going to affect their ability to market the premises covered by the facilities agreement. They claimed that there was an implied term in the contract the bank would not take any steps that would cut across Camden's marketing of its premises. There was nothing expressed in there about this, so it was necessary to establish whether the court should imply a term to that effect into the facilities agreement. The bank said the arguments for an implied term restricting its actions were hopeless, and so it applied to strike out the case. The Court of Appeal had to decide whether the bank was able to strike out Camden's claim, because it was hopeless. Well, the Court of Appeal said that the starting point in looking at whether or not a term could be implied was to look at the express terms of the relevant document. Secondly, it's extremely important that an implied term could not contradict an express term. Interestingly, the court said that a term would be inconsistent with an express term in two different ways. There could be what they called direct linguistic inconsistency. This means the language of the alleged implied term would necessarily contradict an express term. However, here, the court accepted there was no necessarily direct linguistic inconsistency. Situations could arise where the bank's apparent freedom to market the loan it had made to Camden would not cut across Camden's marketing of its properties. In other words, it didn't necessarily follow that the disclosure of the loan documentation by the bank to potential transferees would necessarily be a problem, and so there was linguistic scope for both an implied term and the express term to coexist in the same document. But the alternative form of inconsistency was what the court called substantive inconsistency. Here the Court of Appeal decided that an implied term that the bank would not do anything to hinder Camden's marketing of its premises was inconsistent with the express terms. It would be a significant restriction on the bank. It was not entirely clear how the implied term would operate, and the express clause was an express and unrestricted power to provide this information. And it's perfectly clear, and so the parties couldn't readily be taken to have agreed an implied qualification to that power. It was also pointed out by one of the judges that this was a lengthy and carefully drafted document, and it worked perfectly well without the alleged implied term, which is a further factor against implying the term. So why did I put a finance case into the employment podcast? Am I so jaded with the constant diet of interesting employment cases that I felt we should step out a little, spice up our offering from the Mayor Brown Bishopsgate Employment Emporium? Far from it, of course. Implied terms, beyond the standard duty of mutual trust and confidence, of course, are a feature which can trip up an employer or its advisors. A clause in a contract may look perfectly straightforward, having been drafted by the employer. It reads the way the employer would want it to. However, if the employee can identify an implied term that circumscribes that power, then that may be a very powerful weapon. It's a bit like the redundancy case which we dealt with last week. There, the employers apparently had the express right to relocate employees. But dismissing the employees for refusing to relocate was unfair dismissal. If instead, before being dismissed, the employees had walked out and claimed constructive dismissal in those circumstances, would they have won? Would the court have found that an implied term had been breached? Probably it would have done. Of course, in the employment context, often the duty of mutual trust and confidence is a catch-all. But given that all the cases, both employment and non-employment cases, are clear that implied terms cannot override express ones, I've always wondered why there isn't a brave employer out there who will draft the contract of employment which expressly excludes the duty of mutual trust and confidence. Would that work? Certainly it would be a radical step for the court to determine that there was an implied term in a contract that expressly contradicted an express term. However, if you're trying to argue against an implied term, then looking at the test for inconsistency laid down by this case, and why the court felt there was a substantive inconsistency, well, that could be very helpful. So, that's the case of Irish Bank Resolution Corporation Limited and Camden Market Holdings Corporation. Third and final case, Holyoake and Candy and another. This deals with a High Court decision on data subject access, the so-called DSAR. As I understand it, the Holyoake and Candy litigation is long-running, highly contentious and very definitely continuing. But what we're looking at here is one small piece of that litigation. It's the High Court's decision in relation to Holyoake's data subject access requests for information about him from Mr. Candy and a Guernsey-registered company, CPC. The background, of course, is that the data subject access requests are a powerful weapon for employees because they allow an individual to require, usually the employer, to disclose all personal data held by the employer on its system. Personal data includes things like an expression of an opinion about someone, as well as things that are more obviously directly focused on the employee or about the employee. It's only necessary for the employee to pay a £10 fee. Unlike disclosure in a litigation process, which often runs alongside the DSAR, there's no requirement for the documentation to be relevant to the litigation in any way. It's a classic example. A fishing expedition is permitted to the employee. There are relatively limited circumstances in which an employer is allowed to refuse to disclose information covered by the DSAR, but one of them is information that is covered by legal professional privilege. In April 2016, Mr. Holyoake put in a data subject access request to Mr. Candy and CPC, and in November, these were responded to. Given that the usual timescale for compliance is 40 days, I suspect there's part of the story that doesn't appear in the case reports. Anyway, when the information was disclosed, some of it was disclosed, but some of it was withheld on the grounds that it was subject to the legal professional privilege exemption. First, Mr. Holyoake contended that the defendants had not carried out adequate searches when collating material for the DSAR. Secondly, he challenged whether the documents that were being withheld were being validly withheld on the basis of the legal professional privilege exemption. In particular, what he said was that there was a well-recognised exception to the legal professional privilege exemption, when that exemption is being used as a cloak for iniquity. In these circumstances, it's entirely clear a court may order documents to be disclosed if they are otherwise covering up iniquity. But it seems from the case report that Mr. Holyoake believed, for whatever reasons, that he'd been placed under surveillance by someone on the defendant's side, and it looks as if this is partly what underlay the DSAR. There was a third issue, which was parked, and that was a full-on attack by the defendants in this case on whether DSAR requests should be used alongside the litigation process. This is a case that is awaiting an outcome on a different set of cases in the Court of Appeal, and I'll definitely want to talk about those when we have the outcome. Certainly at the moment it can be very frustrating for the employer to find that the careful and balanced rules on disclosure and litigation can be sidestepped entirely by a claimant putting in a DSAR request. The judge decided here that the defendants had carried out adequate searches. He decided, and this is crucial, that the focus of a DSAR search is limited to conducting a, quote, reasonable and proportionate, unquote, search. The defendants had looked at over 17,000 individual documents, and significant time charges had been incurred. One matter that the claimant asserted had been overlooked was whether CPC's directors should have been asked to disclose the contents of their personal email accounts, i.e. emails on their personal devices, which should be searched. The court accepted that there was no evidence that the directors had used private email accounts for company business. If that had happened, then potentially the individual would have been obliged to give access to his personal email account to the company to enable the company to comply with its DSAR obligations. However, CPC was not obliged to have checked with the directors directly unless there was reason to believe they might have conducted business in this way. And of course, they had no general right to access the personal email accounts of the directors. So, Mr. Holyoake lost on that issue. The judge then considered the legal professional privilege defence and whether to order disclosure, because the legal privilege exemption was being used as a cloak for iniquity. The judge took the view that in this context, iniquity meant something that was a crime or fraud. It did not extend to things such as breaches of human rights. As I say, there was apparently a suspicion by Mr. Holyoake the defendants had been involved or carried out or commissioned or whatever a surveillance operation of him. The claimant argued that this was a breach of his right to privacy, and as such, fundamental breach of his human rights, and therefore if the refusal to disclose the documentation was on the grounds of legal professional privilege, this would be allowing a cloak over the iniquity if the documentation related to such surveillance. However, the judge didn't agree and reconfirmed that the material was privileged. The judge was invited by Mr. Holyoake to look at the offending documentation to check for himself whether it was covered by legal professional privilege. However, the judge refused to do so, saying that that was a step of last resort. In other words, it would be up to the claimant to try and come up with enough evidence to show that those claiming privilege had misunderstood their duty or could not be trusted with the decision-making before the judge would look at the relevant documentation. Accordingly, the claimant's claim in respect to the DSAR failed. I wanted to mention the case because it does have some very useful points in it. First and fundamentally, the decision by the High Court that the duty to search for documentation goes no further than one which is reasonable and proportionate is a really helpful comment. I think in the past it's been viewed as a task that had to be undertaken irrespective of whether the ambit of the search was reasonable and proportionate. We'll have to see what the Court of Appeal, in the cases which they are currently considering, have to say about this point. Secondly, the comments on the director's personal email accounts are also revealing. It's accepted the company has no general right to go in and access personal email accounts. If the director chooses to conduct business on his email account, his own personal one, then the potential for there to be a duty to allow access to the business email is understandable and would put relevant emails within the scope of a DSAR request. The legal privilege exemption is a key part of the balancing of rights as far as the DSAR is concerned. The iniquity exclusion to legal privilege operates in a very restricted fashion. We did a case some years back where we certainly felt that withholding the documentation from the court was iniquitous, but sadly it was not a crime or a fraud, so we were unable to persuade the court to allow it to be used in open court in the particular litigation. So that's the case of Holyoake v. Candy and another. So it only remains for me to say thank you very much indeed for listening. Do hope you found the episode useful. And we will be doing another episode in 2 weeks' time, episode 111. Thank you.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.